Hello and welcome to Unacademy, India's largest online learning platform. And also welcome to Crack CA Exams with us, that is the vertical of Unacademy that provides to you top educators, quality content, and overall a great learning experience. So come, let's crack CA Exams with Unacademy, India's largest online learning platform, which gives you a world of courses, resources, content, live and recorded sessions of your favorite educator of your favorite topic and enhances and accelerates your preparation for the CA Foundation and the intermediate examination. Welcome once again. Before we proceed, a little introduction about the educator today, that is me. Hello, I'm Prathik Gupta. I am a Bachelor of Commerce from Christ College, Bangalore University. I am an associate member of the Institute of Chartered Accountants of India, an associate member of the Institute of Cost Accountants of India, and an associate member of the Institute of Company Secretaries of India. Along with this, I'm also a law graduate from Karnataka State Law University and currently a practicing chartered accountant. I'm also a visiting faculty for CA subjects and an educator for CA students both offline and online. Prior to starting on my own, I worked with SR Bartley Boy and Associates, that is the Indian member firm of Ernst & Young Global, that is EY Global in the Audit and Assurance Department, and Ernst & Young India in the Mergers and Acquisitions Department. I also worked with the Manipal Group and was the corporate controller of their Indian and the German subsidiary located in Frankfurt, Germany. It was when I got back from Frankfurt, Germany that I decided to start something on my own. And here I am today having this privilege to take this session for you bright and young CA aspirants. So welcome to my session, and anytime during my session, in case you have any questions or any doubts, please feel free to ask and I will be more than happy to answer them for you. In case you want to know anything, you want to discuss something, please do drop in a message and I will be happy to address that for you. Now, the Unacademy platform provides you courses on 3 platforms. That is, one is on YouTube, what you're viewing now. Then you have special classes. Okay, and then there is a third important and the most important point of platform of Unacademy, that is the Plus platform. So YouTube are the one you're looking now, what I'm addressing you right now. Then there are special classes. Special classes are classes on very important topics that are conducted on the Unacademy Learning app, more about which I will tell you in the following slides. And please remember, YouTube and special classes are absolutely free classes, and there are a lot of topics and a lot of discussions on these which help you in your preparation for the CA Foundation and intermediate examination. Alright, so now let's come to the Plus course. Now, Plus course on the Unacademy platform is a payment-based subscription model which gives you various packages for the courses of your choice. Similarly, there is a package for the CA Foundation and intermediate course as well. I personally suggest to you to go on the Plus platform of Unacademy because you get a lot of benefits from doing so, and it also accelerates and enhances your preparation for the CA Foundation and intermediate course. So what are the benefits that you get? The first benefit that you get are daily live classes where you get to chat with your educator, engage in discussions, ask your doubt and answer polls, all this while the class is going on. Yes, you heard it right. All this while the class is going on. You get to choose your educator, choose your topic of your choice, and then chat with your educator, ask doubts, discuss matters. All this in real-time basis when the class is going on. You do not need to wait for a different day, or you do not need to wait for a different session. You do not need to wait for end of the class. You can do it as simply as raising your hand like you do in a live classroom and ask your doubts and clear your queries. Alright, the second reason why I recommend and encourage you to be a part of the Plus platform of Unacademy is the Plus platform of Unacademy conducts various live tests and quizzes which help you in your preparation with the regular mock tests and quizzes and get detailed analysis of your performance. So what happens when you get a detailed analysis of your performance and also your preparation is evaluated? You get to know which are the topics that you've prepared really well. You get to know which are the topics that you're not so well prepared. So in short, it helps you in identifying your weak areas, your strong areas, and your not so strong areas. So what happens once you identify your weak areas, your strong areas, and your not so strong areas? It just helps you in channelizing and diverting your time rightly more to the weak areas and your not so strong areas and lesser time on your strong areas. So this eventually will help you in minimal wastage of time and maximum utilization of time. The third reason why I recommend the Plus platform or the Plus course of Unacademy is for the following reason: because the courses provided by the Plus platform are structured courses. They are structured because they are completely in line with the syllabus of your examination, and they are prepared keeping in mind the syllabus of your examination. So once you have completed a Plus course on the Plus platform, you can be assured that you have completed the syllabus of your examination without missing any important or major point. And lastly, and most importantly, the one subscription to the Plus platform of Unacademy gives you unlimited access to all the live and recorded courses of your favorite educators or your favorite topics, all this from the comfort of any of your devices. That means you can view those live and recorded sessions of your favorite educators, favorite topics on your mobile phone, on your tablet, on your laptop or your desktop. Okay, and more importantly, you can access it at any point in time you want, and from any location. All you need is a good Wi-Fi connection or a data plan, and there you go. You are ready to attend your session and prepare for the CA Foundation and Intermediate examination. So I personally would recommend you to get onto the Plus platform as soon as possible and accelerate and enhance your preparation for the CA Foundation and Intermediate course. Like I told you, the Unacademy platform works on YouTube, special classes and Plus. So the special classes, which are various important classes or sessions on important topics from the exam point of view for the CA Foundation and Intermediate sessions, and the Plus platform, which I just explained to you in the previous slide, which is a payment-based subscription model. Both these courses are available on the Unacademy Learning app. So all you need to do is you need to go to your Play Store, download the Unacademy Learning app, and register on it using your mobile number. You need to put in your mobile number, you get an OTP. Using that OTP, you need to register on the Unacademy Learning app, and you're done with it. The process is as simple as that. And while doing so, in case you have any problems, you can always chat with the concerned person and clarify your doubts and make the process more easier. So what happens once you sign into or register onto the Unacademy Learning app? Once you register or sign into the Unacademy Learning app, it opens your gateway to the world of special classes and the Plus course that Unacademy has to provide to you, provided you have subscribed to the Plus course. But please remember, the special classes and the YouTube sessions are absolutely free of cost, but they also do help you, and there are various important topics that are covered in these special classes that eventually help you in your preparation of the CA Foundation and Intermediate course. So for those of you who have not even attended the special classes, I request you to download the Unacademy Learning app, register on it using the mobile number and the OTP, and please go through the various special classes that are there on the app and benefit from that. All right, so we will, and for those of you who are downloaded the Unacademy Learning app and are using it, I thank you very much, and I request your support in the future as well. And for the people who have not yet downloaded it, please do go to your Play Store, download the Unacademy Learning app and register on it using your mobile number and your OTP. Now, like I told you, the Plus platform is a payment-based subscription model, okay, which provides you various subscription packages for the CA Foundation and Intermediate course. So the CA Foundation and Intermediate subscription packages under the Plus platform of Unacademy are as follows. The packages are provided for 1 month, 3 months, 6 months, 12 months and 24 months. The 1 month normal cost of the package is 3,500. The 3 month package normally costs you rupees 8,750. The 6 month package normally costs you rupees 14,000, and the 12 month package normally costs you rupees 17,500, and the 24 month package will cost you rupees 21,000. While you decide the package of your choice, please do not forget to use the code Prathik, Prathik, that's me, to get a discount of 10% on the list price. I repeat, Prathik, to get a discount of 10% on the list price. So I personally would, so the after discount cost of the various packages are: the 1 month package will cost you rupees 3,150, the 3 month package will cost you rupees 7,875, the 6 month package will cost you rupees 12,600, the 12 month package will cost you rupees 15,750, and the 24 months package will cost you rupees 18,900. Okay, so you see immediately after using my code, that is Prathik, you get a discount of 10% on the listed price. So the after discount prices are given to you in front of you. Now, I personally would recommend you to go for the 12 months package or the 24 months package for the following reasons. Firstly, it is cost effective. If you see the per month cost of the 1 month package and compare it with the per month cost of the 12 months and 24 months package, it's almost less than 1/3 of the 1 month package cost. So it's already cost effective Okay, and secondly, as the CA Foundation and the intermediate subscription is being provided to you in one package, it makes sense for you to go for at least the 12 months, because it normally takes about a year's time for you to prepare and clear the CA Foundation and intermediate examination. And in case you're getting the CA Foundation and the intermediate subscription for that duration, and that too at a cost-effective price, it makes sense for you to opt for the 12 months package at least. Alright, so when you decide the package of your choice, I request you to use the code Prathik, Prathik, to get a discount of 10% on the list price. Alright, so I repeat, Prathik, that's my name, and you immediately get a discount of 10% on the list price. I request you to just go through the subscription packages, take about a minute or so, and then we proceed. Please remember, the YouTube as well as the special classes are absolutely free of cost, and the Plus platform is a payment-based subscription model which gives you enhanced features and benefits. Now, like I told you, the special classes that are conducted on the Unacademy Learning app, here are the glimpses or the screenshots of the various, a few of the many special classes that I have conducted on the Unacademy Learning app. Like I have taken special class on the revision test papers May 2019, business laws issued by the Institute of Chartered Accountants of India. I have taken a special class on the Sale of Goods Act 1930, the Indian Contracts Act 1872, the Companies Act 2013. So these are a few of the many special classes that I have taken, and all these special classes are present on the Unacademy Learning app. So I request you to download the Unacademy Learning app from your Play Store and use this opportunity to go through all the special classes to help you in your preparation for the CA Foundation and the intermediate examination. Now, here are also a few of the links to my special classes on the Unacademy Learning app. I have taken special class on the Indian Contracts Act 1872, special class on the Sale of Goods Act, special class on the Indian Partnership Act, special class on the Limited Liability Partnership Act, special class on the Companies Act 2013, a special class on the Basics of Communication, a special class on the accounting concepts, and also special class on the various revision test papers for CA Foundation issued by the Institute of Chartered Accountants of India. So these are few of the many special classes that I have taken on the Unacademy Learning app. So I request you to click or copy paste any of the links and go through the special class and benefit from it. And in case you have any observations or doubts during those sessions, please feel free to ask me, and I will be happy to answer them for you. All right, but for these, to access this, you'll have to download the Unacademy Learning app and register yourself on it, and then you can access the various special classes. Okay. Now we come to today's topic. The topic that we're going to discuss today is the Indian Contracts Act 1872, and a subdivision of that we're going to discuss specifically about the contract of indemnity and guarantee. Okay, now if you see the earlier sessions on YouTube that I have taken just earlier in the day today, I have taken a session on YouTube on the Indian Contracts Act 1872 and the features of bailment and all right, so discussing the procedure of bailer and bailee and all that. And then earlier yesterday I took a session on Indian Contracts Act 1872 discussing the entire chapter on agency, that is how is the principal agent relationship and how it works. So today the topic is specifically on the contract of indemnity and guarantee contained in the Indian Contracts Act 1872. Now before we start this, I would like to tell you that I have taken a lot of special classes on Indian Contracts Act 1872, which is present on the Unacademy Learning app, and you can access it by going to the Unacademy Learning app. So there are solid 2 or 3 hours or 4 hour sessions taken on Indian Contracts Act where every minute detail of the Indian Contract Act is discussed. So you can attend that and benefit from it. And meanwhile, in today's session, we're going to talk about contract of indemnity and guarantee contained in the Indian Contracts Act 1872. All right, and during the session, in case you have any questions or anything, please do feel free to ping, and I will be happy to answer them for you. Okay, so let's start with the brief introduction. A contract of indemnity and guarantee are the specific types of contracts given under sections 124 to 147 of the Indian Contracts Act 1872. Along with the specific provisions, that is section 124 to section 147 of the Indian Contracts Act 1872, the general principles of contracts are also applicable to such specific contracts. Both the contracts are modes of compensation based on certain similar principles. However, both differs from each another in several issues. In this unit, we will discuss the law relating to indemnity and guarantee and discuss those things in detail. So, like I said, this even a contract of indemnity or guarantee are another type of contract, and all the essential features of a valid contract under the Indian Contracts Act 1872 are applicable to contract of indemnity and guarantee as well. Okay, so the various essential elements of a contract, that is a fair, a valid acceptance and offer, free consent, fair consideration, lawful object, the agreement or contract should not expressly be void. So all these are applicable to contract of indemnity and guarantee as well, and in addition to those, they have certain additional features or characteristics which we shall discuss in today's discussions in detail. So in case of any questions at any time, at any point of time, please feel free to ask me. Okay, now let's look at what does a contract of indemnity mean. Okay, or what is a contract of indemnity? The term indemnity means to make good the loss or to compensate the party who has suffered some loss. Okay, so the basic term indemnity will mean to make good a loss or to compensate the party who has suffered some loss. So if there is any party that has incurred some losses or damages, then a contract of indemnity will be to make good that loss or to compensate that person who has undergone the loss. The contract of indemnity is defined under section 124 of the Indian Contract Act 1872. All right, so it is the contract by which one party promises to save the other from losses caused to him by the conduct of the promisor himself. Okay, so let's look at the definition of a contract of indemnity as per section 124 of the Indian Contracts Act. It is the contract by which one party promises to save the other from loss caused to him by the conduct of the promisor himself or by the conduct of any other person. So it is a contract between two people where one person undertakes to compensate the other person of any loss that the second person might incur due to the actions of the first person or due to the actions of some other person. So that is a contract of indemnity. Okay, indemnity means indemnify or reimburse. So I repeat again. So according to section 124 of the Indian Contracts Act 1872, a contract for indemnity is a contract by which one party promises to compensate or make good the loss occurred to another person, either by the conduct of the first person or by conduct of any other person. Okay, so that is the meaning of contract of indemnity as per section 124 of the Indian Contracts Act 1872. Let's look at an example. Mr. X contracts with the government to return to India after completing his study at the University of Cambridge and serve the government for a period of 5 years. If Mr. X fails to return to India, he will have to reimburse the government. It is a contract of indemnity. So the example says, now there is a person who is working with the government. Okay, so he enters into a contract with the government and says that, okay, let me or please sponsor me my education in the University of Cambridge. And once I finish my studies in the Cambridge, once you sponsor my education at Cambridge and once I finish studying there, I will come back and I promise I will work with the government or with the company for a period of 5 years. So the government says okay, and the government sponsors his studies at the University of Cambridge. So after he finishes studies at the University of Cambridge, he does not come back to India, or he gets a better job offer there and he goes and joins a job there. So in this case, if Mr. X fails to return to India, then he will have to reimburse the government. It is a contract of indemnity. So indemnity simply means to make good the loss the other person has incurred due to your action or due to someone else's action. So that is what indemnity means. There are two parties in this form of contract. The party who promises to indemnify, save the other party from loss is known as the indemnifier, whereas the party who is promised to save against the loss is known as indemnified. So the two parties in a contract of indemnity are, one is an indemnifier, that is the person who promises to make good the loss to the other or to save the other party from loss. That person is the indemnifier, whereas the party who is promised to be saved against the loss is known as indemnified or indemnity holder. Okay, please take about a minute or two, go through this, and then we proceed. In the meantime, any questions, please ask me. Okay, now let's take another example. A may contract to indemnify B against the consequences of any proceedings which C may take against B in respect of a sum of rupees 5,000 advanced by C to B. In consequence, when B is called upon to pay the sum to C, fails to do so, C would be able to recover the amount from A as provided under section 124. So this also means, now let's take an example where A may contract to indemnify B. That means A contracts to make good the loss to B against the consequences of any proceedings which C may take against B. So let's understand the example. B has borrowed money from C. Now A enters into a contract with B to indemnify B in case C goes ahead and files a case against B for the recovery of rupees 5,000. Okay. Now in consequence, when B is called upon to pay the sum to C, so let's say the court now says, okay, now B, please pay rupees 5,000 to C, and B fails to do so. Okay, and B says, no, I don't have the money, I'm not paying you. In that case, C would be able to recover the amount from A as provided in section 124. So again, A will be the indemnifier and C will be the indemnified or the indemnity holder. Okay, let's look at example number 2. X, a shareholder of a company, lost his share certificate. He applied for the duplicate. The company agreed to issue the same on the term that X will compensate the company against the loss where any holder produces the original certificate. Here there is a contract of indemnity between X and the company. So let's try to understand the second example as well. X is a shareholder of the company and has lost his share certificate. Now please remember, a share certificate is a very important document to prove that you are the shareholder or you are the valid holder of a certain number of shares. So he applied for duplicate share to the company. The company agreed to issue the same on the term that X will compensate the company against the loss where any holder produces the original certificate. So his share certificate is lost. So if anyone who finds it brings the original share certificate, and due to which the company incurs any loss, then the X should reimburse or indemnify the company of that loss. Okay, here the contract is of indemnity between X and the company, and X is the indemnifier and the company is the indemnified. All right, so X will have to reimburse the company in case the company incurs any loss due to he losing his share certificate. Let's look at example number 3. X may agree to indemnify Y for any loss or damage that may occur if a tree on Y's neighboring property blows over. If the tree then blows over and damages Y's fence, X will be liable for the cost of fixing the fence. Okay, so let's take an example here again. X may agree to indemnify Y for any loss or damage that may occur if a tree on Y's neighboring property blows over. If the tree then blows over and damages Y's fence, X will be liable for the cost of fixing the fence. Alright, so there is a tree that is there on X's property, and X enters into a contract with Y saying that if the tree on my property blows over and damages your property, then in that case I will be liable for the cost of fixing the fence. Okay, so here again we see in this example, X X is the indemnifier and Y is the indemnified. Please take about a minute, go through this slide, and then we proceed. Yes, Anil, what's your question? Any time restriction in this? I mean, I didn't understand your question. If you could specify your question, I will explain it to you. Okay, now let's look at the mode of contract of indemnity. So far we've understood what a contract of indemnity is. A contract of indemnity is a contract where the indemnifier agrees to make good the loss caused to the indemnified due to the action of the indemnifier or to the action of someone else. That is a contract of indemnity. Now let's look at the mode of contract of indemnity. A contract of indemnity, like any other contract, may be expressed or implied. That means it can either be in words which are written or said, or it can be implied. Implied means through it is a contract that is created through the actions of certain parties. Okay, now a contract of indemnity is said to be express when a person expressly promises to compensate the other from loss. Okay, so when a person comes up and says, okay, I promise to make good the loss to you caused by me or by any other person, and he says it in so many words or he gives it in writing, then it is known as an express contract. Okay, but whereas a contract for indemnity in which is said to be implied when it is to be inferred from the conduct of the parties or from the circumstances of the case. Okay, like for example, if a person is about to carry on a stunt on a bike, a dangerous stunt on a bike, and he is hesitating to do so. Okay, but the person sitting next to him or the standing next to him says, no, go ahead. Anything happens, I will take care. Or don't worry, I am there. So that is again by indemnity is said to be implied by the actions of the other person. Or after he is hurt, the other person rushes him and takes him to the hospital and makes good the loss. Then that is a contract of indemnity by implied, not expressed contract. Okay, so a contract of indemnity is like any other contract and must fulfill all the essentials of a valid contract, which includes, like I told you in the beginning, a contract of indemnity is also a sub part of a contract under the Indian Contracts Act 1872 and must fulfill all the essentials of a valid contract, which includes, first one, an offer and acceptance. So there should be a valid offer and a valid acceptance. If there is no valid offer and valid acceptance, there is no contract. The offer can be specific or it can be general, and the acceptance has to be made to that offer and communicated to the offeree. The offeree has to communicate the offer to the acceptor. Okay, next, the intention to create legal obligation. Obviously, for any contract or any agreement to become a contract, there has to be a legal obligation. If there is no legal obligation, there is no contract. Legal obligation simply means that the people into a contract should be legally responsible or should be accountable for their actions or their inactions. If they do something, then if they commit to something, they should do it, and in case they don't do it, then there are legal repercussions of the same. That is what you mean by legal obligation. The third part is consideration. All contracts should have a valid consideration, and any contract without a consideration is not a valid contract, barring a few. There are few contracts in which there is no need for consideration, like a contract out of love and affection, time bar debt. Then there is gratuitous act, finder of goods. So all these contracts can be done without a consideration. Other than this, if there is any contract, there has to be a valid consideration, and the consideration should be valid in the sense it should not be unlawful or illegal. It should be a legal and valid consideration. Then the fourth point of the capacity to contract is the competence to contract. The people entering into a contract should not be minor, that is below the age of 18, should not be a person of unsound mind, or should not be a person who's been declared insolvent by a competent court. So the people entering into a contract or a contract of indemnity should be competent to contract. They should not be disqualified from entering into a contract. Then there should be free consent. So the essential, one of the again essential qualities or features of a contract as per the Indian Contracts Act 1872 is again a free consent. That means consent of either party should not be obtained through fraud, coercion, undue influence, or mistake. A fraud means an act done with an intention of deceiving someone. Coercion means forcing them or threatening them to carry out an act which is prohibited under the Indian Penal Code. Undue influence means when a person is in a position to influence the decision of the other person and he does so. Misrepresentation is again lying and representing things to be true when he knows that the thing is not true, and a mistake. So if consent is obtained through any of these means, that is fraud, coercion, undue influence, misrepresentation, or mistake, then the contract is said to be void because it is not said to be a free consent. Then we have lawful object. The object of the yes, Anil, now you're talking about bank guarantee. Yes, we will discuss that when we reach the stage of guarantees. Okay, so I request you to hang on and wait till we reach guarantees. Okay, we are talking about indemnity at the moment. All right, so now the object of the agreement or the contract should be lawful. It should not be a contract to go and kill someone or kidnap someone or extort money out of someone. The object of that contract, whether it is a normal contract or it is a contract of indemnity, should be lawful and legal, and it should not be illegal. The agreement must not be expressly declared to be void. An agreement in restraint of trade marriage is declared to void. So there are certain agreements as per the Indian Contracts Act 1872 that are expressly declared to be void. So it should not be one of those agreements. Now examples of an agreement expressly declared to be void are an agreement in restraint of marriage. That means a contract or agreement stopping someone from getting married, or stopping someone to get legal recourse, or stopping someone to act in a particular or to carry on a particular trade. Okay, so these are a few of the agreements that are declared to be void, and these agreements are void. They are right from the beginning. They are void ab initio. That means from the initial stages they are void. And then the terms of the agreement must be vague or certain. The terms of the agreement must be clear and specific. If there is any terms of the agreement that are vague or certain, like for example, I will pay you 100 rupees to go and bring me some vegetables. That's vague. Yeah, I will pay you 100 rupees to go and bring me 5 kgs of mangoes. That's specific. All right. So your terms of the agreement must not be vague and it should be clear. All right. Please take about 2 minutes and brush up on the essential features of a contract, which are also applicable to a contract of indemnity. Okay. Please go through this and then we proceed. Please take about a minute or two, go through this, and then we proceed. Take about a minute more, go through this. Okay, now let's look at the rights of the indemnity holder when sued. Okay, so now the indemnity holder is a person who has to be indemnified by the indemnifier. All right. So now when he sues, then what are the rights he has? The promisee in a contract of indemnity, acting within the scope of his authority, is entitled to recover from the promisor or the indemnifier. All right. So once there is a contract of indemnity where the indemnifier agrees to make good the loss occurred to the indemnity holder or the indemnity holder for any acts of the indemnifier or any other person, and let's suppose the act happens. So when the indemnity holder files a case against the indemnifier, what are the rights does he have? So let's see the first right. The indemnity holder has the right to recover all the damages which may have been compelled to pay in any suit in respect of any matter to which the promise to indemnify applies. All right. So let's say there is an agreement, A and B. A is the indemnifier and B is the indemnity holder. Now, in case indemnity holder has to file a case, so all the legal charges, the bank fees, whatever court costs, court fees and expenses that the indemnity holder incurs, he is liable to get all those reimbursed from the indemnifier for every case. Okay, it cannot be that the indemnity holder incurs all those costs and the indemnifier just escapes. So the indemnifier will be liable to pay him all those legal costs. Okay, let's look at the next point. All costs which he may be compelled to pay in any suit, if bringing or defending it, he did not contravene the orders of the promisor and acted as would have been prudent for him to act in the absence of any contract of indemnity, or if the promisor authorized him to bring or defend the suit. All right. So in this case, if the indemnity holder has done every action on his part which he was supposed to do rightly, and it's not his fault, and it is mainly the fault of the indemnifier, and the indemnity holder has acted as would a man of prudence would have done. In that case, if the indemnifier files a case against him, or he files a case against the indemnifier, in both the cases, whatever the costs are involved to pay in that suit will be reimbursed by the indemnifier. Okay, so the indemnity holder can claim it from the indemnifier. Okay. Anil has a question. Is there any time restrictions in the indemnity, like the loss has to claim within that time period? All right, Anil. See, that again depends on the contract between the indemnifier and the indemnity holder. Okay, so if the contract gives a time, then that particular reimbursement or thing has to be claimed within that time. Okay, but if you're talking about recourse to claim the time, then you need to go for the Limitation Act. The Limitation Act gives you the time period within which a suit or a claim for a particular relief can be claimed, and then we need to fall back on the Limitation Act. All right, Anil. So we'll have to look at that. We'll have to look at the agreement as well as the Limitation Act. Okay. Then the third point, the third rights, all sums which he may have paid under the terms or any compromise of any suit, if the compromise was not contrary to the orders of the promisor and was one in which it would have been prudent for the promisee to make in the absence of any contract of indemnity, or if the promisor authorized him to compromise the suit. So in case there is any compensation or anything that he's paid, or any compromise that he's already paid to the indemnifier which he was not supposed to, then he can claim for that money as well when he files a suit against the indemnifier. So I request you to take about 2 minutes, go through this and let me know, and then we proceed. Please read it carefully in case you have any questions. Hello Pratham, how are you? Thanks for joining in. In case you have any questions, please ask me and I shall be happy to answer it. Any questions, please ask me. Okay, let's proceed. Now, when does the liability of the indemnifier commence? Okay, so in the previous slide, we saw the rights of the indemnity holder in case he files a suit against the indemnifier. So now let's say he has filed a case against the indemnifier. So the next question is, when does the liability of an indemnifier commence? Okay, all right, Anil, did I answer your question right? You seem to be convinced with the answer? Yes? All right. Most welcome, Anil. Any other questions? Please feel free to ask me. Okay. Although the Indian Contract Act 1872 is silent on the time of commencement of the liability of the indemnifier, however, on the basis of judicial pronouncements, it can be stated that the liability of an indemnifier commences as soon as the liability of the indemnity holder becomes absolute and certain. All right. The principle has been followed by courts in several cases. Now let's take for example. Now, see this, if you see this, when does the liability of an indemnifier commence? The Indian Contracts Act 1872 is silent about when does it start. But based on a lot of judgments in several cases, the liability of the indemnifier begins when the liability of the indemnity holder becomes absolute and certain. All right. So now let's take an example. Let's take that there is A and B, they are friends, and B goes on, urges A and says, okay, you go on a bike and put a stunt and this thing, and if anything happens to you, I will reimburse the medical cost for you. A does not want to do it, but B urges him and pushes him to go and do it. So A does it. Now the question is, when A falls down from his bike, he gets hurt. Okay. Now the question is, when does the liability of B commence? Now A has got hurt, A has fallen down on the road. Now A will be taken to hospital, there will be a lot of x-rays, there will be a lot of tests that will happen, everything, the treatment will happen, and after about a month, when you get the final bill of his injury or what happened to him, so that is when the liability of the indemnity holder, that is A, becomes absolute and certain. When the hospital gives you the bill, that time it becomes certain, okay, it was a bill for 10 lakhs. So when the bill for 10 lakhs comes, that is when the liability of the indemnifier commences. Okay, that means when the indemnity holder comes to know that what is the loss that he has incurred, that is when the liability of the indemnity holder or the indemnifier begins. Are we clear? All right, let's take an example. A promises to compensate X for any loss he may suffer by filing a suit against Y. The court orders X to pay Y damages of rupees 10,000. As the loss has become certain, X may claim the amount from A and pass it to Y. So now A tells Y that, okay boss, go and file a case against Y, and if you incur any losses during this thing, I will repay it to you. So looking at that, X very confidently goes to the court and files a case against Y, but everything backfires on him, and the court orders X to pay Y a certain sum, a sum of rupees 10,000. Okay, so now as the court has given the order, that means when the liability of X becomes certain on the giving of the court's order, A's liability commences. So X can claim that amount from A and pay it to Y, or he can pay it to Y and claim that amount from A. So this is how the liability of the indemnifier commences. All right, please take about 2 minutes, go through the slide, and then we proceed. In case you have any questions, please feel free to ask me. Take 2 minutes, go through this. Any questions, please ask me. Okay, next we look at a contract of guarantee. Now what do you mean? Now so far we discussed about what is a contract of indemnity. Now let's look at what do you mean by a contract of guarantee. All right, Anil, in case you're here and you have any questions on this, please feel free to ask me. Okay, we're going to discuss about contract of guarantee. All right. So now let's start off. A contract of guarantee, surety, principal, debtor, and creditor. So the main terms in the contract of guarantee are surety, principal, debtor, creditor, and a contract of guarantee. So we will look at each thing in detail before we proceed. A contract of guarantee. A contract of guarantee is a contract to perform a particular promise, made or discharge the liability of a third person in case of a default. Okay, so basically a contract of guarantee is nothing else but a person, the third person gives a contract, gives a guarantee on your behalf. Okay, he simply, let's say A owes rupees, A wants to purchase materials from B, but A does not have the money. Okay, so A thinks that I'll purchase the material from B, I'll make the particular goods, I'll sell it, and then when I get the money after sale, I will pay it to B. This is what A's plan is. Alright, so A goes to B and says, boss, please give me this material. I don't have the money to pay you right now, but please give it to me on credit for 3 months, and within 3 months, I will pay you the money. So B says, no boss, I don't know you. So how can I trust you, or how can I give you the material? So what does B say? B says, please go and get some guarantee or surety if you have. Okay, so A says, okay. He calls his friend and he says, see sir, I need to buy this material. I'm starting a business. I don't have the money. Help me to buy this material. And once I make the final goods out of this material, I will sell it and then repay the money to B. So his friend says, okay, chalo, come, I'll come and give you I'll come and talk to the vendor. So he comes and so his A's friend comes and talks to the vendor and he says, how much is the materials worth? So B tells him it is 50,000 rupees. So A says, okay, so A's friend says, okay, no problem. I give the guarantee for that. Okay, that in case this person does not pay you in a period of 3 months, then you please come to my house and you take the 50,000 rupees. So in this case, this is a contract of guarantee between A's friend and C. Okay, so A's friend is also known as a surety. A surety is a person who gives a guarantee, and the principal debtor is the person on behalf of whom the guarantee is given, and a principal creditor is a person to whom the guarantee is given. So in this particular case, B becomes the principal creditor, A becomes the principal debtor, A's friend becomes the surety. Okay, so 3 parties are involved in a contract of guarantee, that is and principal creditor. So these are the 3 parties involved in a contract of guarantee. In the meantime, take about a minute, go through this slide, and in case you have any questions, please ask me. Any questions, please ask me. Take about a minute. Take about a minute more, please. Okay, now let's take an example. Let's take example 1. When A requests B to lend rupees 10,000 to C, okay, and guarantees that C will repay the amount within the agreed time, and that C, on failing to do so, he, that is A, will himself pay to B. There is a contract of guarantee. Here B is the creditor, C is the principal debtor, and A is the surety. Alright, so in the first example, A requests B to lend 10,000 to C. Okay, and also guarantees that in case C does not repay the money to B within the agreed time, then A will pay the money to B. So then in this case, there is a clear contract of guarantee. Now here the 3 parties are: B is the principal creditor, C is the principal debtor from whom the money is to come, and A is the surety of C. Okay, so this is very important to understand. You need to understand the concept of guarantee. All right, now let's take the second example, where A obtains housing loan from LIC Housing, and if B promises to pay LIC Housing in the event A fails to repay. It is known as a contract of guarantee. Now, obviously, when you take a loan from any institute or any banking institute, you're supposed to repay it, right? So when A goes to LIC Housing and asks them for a home loan, they say, please provide a security. A says, no, I don't have a security. This is my first house and I don't have any property that I own. So LIC Housing refuses to pay him or to give him the loan. So in that case, A's friend comes and guarantees that in case A defaults in repaying the loan, then I will repay the loan to LIC Housing. So in this case, LIC Housing becomes the principal creditor. A becomes the principal debtor, and B becomes the surety. Okay. All right. Now let's go to example number 3. X and Y go into a car showroom where X says to the dealer to supply latest model of WagonR to Y. In case of Y's failure to pay, X will pay for it. This is the contract of guarantee because X promises to discharge the liability of Y in case of his default. So X and Y go into a car showroom. They are best of friends. So X and Y go into a car showroom where X tells the dealer that please show a WagonR to Y and let him buy it. And in case he fails to pay for the car, I will pay it. So in this case, X becomes the surety, Y becomes the principal debtor, and the WagonR showroom becomes the principal creditor. All right. Now let's get to the analysis. Now from the definition, it can be analyzed that guarantee is a promise to pay a debt owed by a third person in case the latter does not pay. All right. So basically a contract of guarantee is nothing else but a promise to pay a debt of a third person in case he does not pay it. All right. So only in case he does not pay it, then it has to be paid by the person who's giving the guarantee. So any guarantee may be oral or written. Like any contract can be express or implied, oral or written. Contract of guarantee can also be oral or written, but it's always better to make it written because then it comes to legal enforceability. Okay, please take about 2 minutes, go through this slide and then we proceed. In the meantime, if you have any questions, please ask me. Take about a minute more, go through this examples and please ask me if you have any questions. Any questions, please ask me. Okay, now from the above definition, it is clear that in a contract of guarantee is a tripartite agreement. A tripartite agreement simply means a triangular shaped agreement, three parties agreement. There are three parties in this between the principal debtor, creditor and surety, and they are in effect three contracts. Okay, so now here it is a contract, a tripartite agreement like a triangle. So here we have the surety, here we have the debtor, and here we have the creditor. So in effect, there are three contracts. Okay, in one contract of guarantee, there are three contracts. A contract between the principal debtor and the creditor, that means this contract is the first contract between the principal debtor and the creditor, because that is the original transaction, right, for which a guarantee has arisen. A secondary contract between the creditor and the surety. So once the surety gives a guarantee, then there is a secondary contract between the surety and the creditor, that in case the debtor fails to pay, the surety will pay. And once the implied contract between the surety and the principal debtor, whereby principal debtor is under an obligation to indemnify the surety if the surety is made to pay or perform. After the first and second contract, then there is also a third contract between the principal debtor and the surety. That means if the surety is made to pay a debt which the debtor was supposed to pay, then there is an implied contract that the surety can withdraw or reimburse or indemnify that money from the principal debtor. All right. So in one contract of guarantee, there are three contracts. The first one is between the principal creditor and the principal debtor. Then the second contract is between the surety and the principal creditor. And then after the surety is made to pay for the debts of the principal debtor, then there is an implied contract between the surety and the principal debtor. All right. So the surety, if he's paid any money to the principal creditor, he has every right to claim or reimburse that amount from the principal debtor. The right of a surety. So here we see the three contracts. Okay. The right of a surety is not affected by the fact that the creditor has refused to sue the principal debtor or that he has not demanded the sum due for him. So that means once the surety is made to pay the debts of the principal debtor, then it doesn't really matter whether the creditor has asked the debtor for the money or not, but he can reimburse. But the surety can file a case against the principal debtor for the recovery of the sum. Please take about 2 minutes, go through the slide carefully, and any questions, please ask me. Please take about a minute more, go through this, and then we proceed. Okay, so we're going to discuss about the contract of guarantee more in detail further. Okay, now we look at the essential features of a guarantee. The following are the essential features or the requisites of a valid guarantee. That means these characteristics or essentials have to be there in a valid guarantee. Now, what are these? There should be a principal debt. The purpose of the guarantee being to secure the payment of a debt. The existence of recoverable debt is necessary. It is the essence of a guarantee that there should be someone liable as a principal debtor and the surety undertakes to be liable in this default. If there is no principal debt, there is no valid guarantee. So please remember, for a contract of guarantee, the first and the most important step is there should be a debt. The debt should be owed by the principal debtor to the principal creditor. If there is no debt involved, so then there can be no guarantee given for anything. All right. So the first and the most important part is there should be a principal debt. All right. Now, for example, let's take for example, two people are fighting. Okay, and one person is saying that he throws a garbage into my side of the house, and both the people are fighting that, why are you throwing garbage here and why are you throwing garbage there? So then a person cannot step into it like a Superman and say, okay, I am the guarantor or I am the surety that Mr. A will not throw garbage from now on into Mr. B's house. Okay, that will not form a part of a contract of guarantee. For a contract of guarantee, there should be a debt. A should owe some money to B or B should owe some money to C. Only then can contract of guarantee come. If there is any other guarantee or surety given for any other purpose, then it is not a valid guarantee. All right, like I told you, if suddenly a person, neighbor comes and jumps between A and B and says, no, I guarantee you that A will not throw garbage from today onwards, then that is not considered as a valid guarantee as per the Contract of Guarantee Act. All right, so there has to be a principal debt. Now, consideration. Like every other contract, a contract of guarantee should also be supported by some consideration. Like we saw in the essential characteristics of a contract under the Indian Contracts Act 1872, there should be a valid consideration. All right, a contract, a guarantee without consideration is void, but there need to be no direct consideration between the surety and the creditor. As per section 127, consideration received by the principal debtor is sufficient consideration to the surety for giving the guarantee. But past consideration is no consideration for the contract of guarantee. Even if the principal debtor is incompetent to contract, the guarantee is valid, but surety is incompetent to contract, the guarantee is void. So please remember here there are two things. Like we discussed, that every contract, okay, needs to have a valid consideration. Okay, Kangshika, if you're here on the YouTube channel, please ask me your questions here, please. Type in your questions and I will answer your questions here, Kangshika. If you're watching my session today, please answer it. Please ask me the question here during my session. Okay, now, if you see the consideration, it is, there are two parts to it. First and foremost, like I said, there can be no contract without, hi Kishore Sharma, how are you? It's nice to see you in the session, welcome. Any questions, please ask. Kangshika, if you have any questions, please ask me here. Okay, so now the first thing in the consideration you need to remember is there is no contract without a valid consideration. All right, so now you might ask me, why is the surety entering into a contract with the principal creditor and what is the consideration between both of them? Both of them don't have any consideration, but in a contract of guarantee, whatever consideration was there between the principal debtor and principal creditor, that is enough for the surety to enter into a contract with the principal creditor. All right, that is point number one. Next, if the principal debtor is incompetent to contract, let's say the principal debtor is a minor, okay, and he enters into a contract with the principal creditor A, okay, the surety has to be a person competent to contract. If the surety is a person incompetent to contract, then the guarantee is void. All right, so the two things here was, even though there is no consideration between the principal creditor and the surety, the contract is still valid between the surety and the principal creditor. Secondly, the principal debtor can be a person who is incompetent to contract, but surety cannot be a person who is incompetent to contract. All right, please take about 2 minutes, go through this in detail, and then we proceed. I'll just get some water. Yes, Rahul, what's your question? Consideration means something in return. Yes, of course. Consideration can either be a payment or a promise to pay something. So even a promise is said to be a consideration. Any questions? Please ask me. Please take about a minute more. Go through this. This is an important slide. Okay, Mr. Topper, all subject. Rahul, you have no questions? All right. In case you do, please ask me. It's nice to know you have no doubts yet. All right. And that's a nice name. Please take about a minute more and then let's proceed. Okay, now let's look at a few examples. Example number 1, B requests A to sell and deliver to him goods on credit. So B asks A to sell him goods on credit. A agrees to do so provided C will guarantee the payment of the price of the goods. C promises to guarantee the payment in consideration of A's promise to deliver the goods. As per section 27, there is a sufficient consideration for C's promise. Therefore, the guarantee is valid. So now let's look at the example again. Now, B requests A to sell certain goods to him on credit. Okay, A agrees to do so provided B's friend C gives him a guarantee. Okay, so C agrees, okay, A, please go and sell him the goods on credit. I give you the guarantee. In case B defaults or does not pay, I will pay you the money. So here, the consideration as per section 127, there is a sufficient consideration for C's promise. Okay, that C, because C is promising to pay him, he is giving the goods to B. That is a sufficient consideration. That is why the guarantee is considered to be valid. Okay, now let's look at example number 2. A sells and delivers goods to B. C afterwards requests A to forbear to sue B. A sells and delivers goods to B. C requests A to forbear to sue B for the debt for a year and promises that if he does so, C will pay for them in the default made by B. A agrees to forbear as requested. There is sufficient consideration for this. Now let's look at this example carefully again. Okay, now A and B enter into a contract, okay, where A sells goods to B. Now C comes and tells A that please, for 1 year, if B does not pay you the money, please don't file a case against him. And in case after a year's time, if he does not pay you, I will pay you. Okay, so for the 1 year's time, A does not disturb B and does not file a case on him. So it is concluded that it is sufficient consideration that for C's promise, A did not file a case against B. So there is a valid contract of guarantee that comes into existence. Okay, that is example number 2. Now let's look at example number 3. A sells and delivers goods to B. C afterwards, without consideration, agrees to pay for them in default of B. The agreement is void. Okay, now in this case, see, if you see the difference, A sells and delivers goods to B. C afterwards, without any consideration, agrees to pay for them in default of B. In this case, the agreement is void because there is no consideration. There has to be a promise or there has to be a cross consideration. All right. Now, we are talking about the essential features of a guarantee. The first one we saw there is a principal debt. The second one we saw consideration. The third one we see the existence of a liability. There must be an existing liability or a promise whose performance is guaranteed. Such liability or promise must be enforceable by law. The liability must be legally enforceable and not time barred. Okay, so there has to be an existing liability between two people which has to be guaranteed. Okay, and that liability should be legally enforceable by law. If there is any other liability, like for example, I promise that he will not throw the garbage on your side of the house, that is not a liability that is legally enforceable by law. All right, so it must be legally enforceable by law. Please take 2 minutes, go through this slide, and then we proceed. In case you have any questions, please ask me. Take about a minute more. Okay, if you're done with this, let's proceed. All right, now let's look at the fourth essential character of a guarantee. There should be no misrepresentation or concealment. Any guarantee which has been obtained by means of misrepresentation made by the creditor or with his knowledge and assent concerning a material part of the transaction is invalid. So basically, when the creditor is taking a guarantee or asking for a guarantee from someone, then he should disclose the facts of the case very transparently to the surety or the guarantor. In case the guarantor's consent has been obtained through any fraudulent means or by misrepresentation or by lying, in that case, it will not be a valid contract for a simple reason that all the essential features of a valid contract, which includes free consent, is not being obtained. Okay, so let's take a look at the example. A engages B as a clerk to collect money from him. B fails to account for some of his receipts and A in consequence calls upon him to furnish security for his duly accounting. C gives his guarantee for B's duly accounting. A does not acquaint C with his previous conduct. B afterwards make default, the guarantee is invalid. Now, in this case, in the example, A hires B as a clerk to go and collect money on A's behalf. So there have been instances where B has taken the money but he's not accounted it. So that means he's got a record. So then A suddenly in consequence asks him to furnish a security or to give a surety. C comes across and gives his guarantee for B and says, okay, now if there's any shortage, I will take the guarantee. But A does not tell C that B has done it in the past many times and he has been caught doing so. So in this case, if B defaults and if C is called to make good the surety, then the guarantee is invalid because the principal creditor has not disclosed all the facts to the surety. Okay, then fifth one, writing is not necessary. Section 126 expressly declares that a guarantee may be either oral or written. So like I said, a guarantee lies like a contract and a contract may be either oral or written, but again, it's always better if it's written because then the legal enforceability comes into the picture. Okay, then joining of the other co-sureties, where a person gives a guarantee upon a contract that the creditor shall not act upon it until another person has joined in it as a co-surety, the guarantee is not valid if that other person does not join. That implies that guarantee by a surety is not valid if a condition is imposed by a surety that some other person will also join as a co-surety, but such other person does not join as a co-surety. So please remember, when a person is giving a guarantee, he has to do it on his own. He cannot put his conditions that, okay, I will become the surety of this transaction only if at the time of the claim from the surety, someone else will join as a co-surety. And in case the other person does not join, then there is no surety. So a surety or a guarantee has to be absolute and not conditional. All right, please take about 2 minutes, go through this and ask me any questions that you may have. Take about a minute more. Any questions, please ask. Any questions, please ask me. Please go through this in detail. Okay, now we look at the next topic, that is the types of guarantees. Okay, guarantee may be classified under two categories. This is as per the Indian Contracts Act 1872. First one is a specific guarantee. A guarantee which extends to a single debt or a specific transaction is called a specific guarantee. The surety's liability comes to an end when the guaranteed debt is fully discharged or the promise is duly performed. Okay, so like the name says, a specific guarantee is guarantee provided for a particular transaction or a single debt. It is not provided for a number of debts or for a period, for a single debt. And this guarantee comes to an end when either the principal debtor repays the amount or the guarantor repays or settles the amount. Okay, now the example for this is A guarantees payment to B on the price of 5 bags of rice to be delivered by B to C. So B is selling some goods to C and A guarantees C's payment to B and to be paid for in a month. B delivers 5 bags to C, C pays for them. This is a contract for specific guarantee because A intended to guarantee only for the payment of price for the first bags of rice delivered one time. So this is a case of specific guarantee. Okay, so now next we come to continuing guarantee as per section 129. Now as per section 129, a guarantee which extends to a series of transactions is called a continuing guarantee. A surety's liability continues until the revocation of the guarantee. So specific guarantees for a single debt or a single transaction, whereas a continuing guarantee extends for a period of time or for a series of transactions. So a person can come and say, okay, I guarantee that for the next 10 days, whatever purchases he makes, I guarantee the payment for that. Then that is a continuing guarantee. All right. Now let's take the example. Example: on A's recommendation to B, a wealthy landlord employs C. So A recommends C, and B, who's a wealthy landlord, employs C as his estate manager. It was the duty of C to collect rent on the first of every month and from the tenant of B, and remit the same to B before 5th of every month. So A recommended to B that C is a very good guy, he knows all his work, so please appoint him as an estate manager. So B, who's a wealthy landlord, listened to A and he appointed C as a the estate manager. So C's duty was to collect the rents of everyone, of all B's tenants, on the first of every month and remit the same to B before 5th of every month. Okay, a guarantee A guarantees this arrangement and promises to make good any default made by C. This is a contract of continuing guarantee. So basically A was so confident about C that he told B that you don't worry, anytime if he defaults, if you don't get the rent or he runs away with the money, I will pay you the money. So this was an example of a continuing guarantee. All right, so now this is important to know the types of guarantees. Please go through this. Take 2 minutes, go through this, and then we proceed. Any questions, please ask. Take about a minute more and then we continue. Any questions, please ask me. Okay, now let's look at an important topic, which is the distinction between a contract of indemnity and a contract of guarantee, which we have discussed so far. So this table will give us in detail the differences between a contract of indemnity and a contract of guarantee. So the first column is points of distinction. The second column is contract of indemnity, and the third column is contract of guarantee. So let's start off the first one. The number of parties or parties to the contract. Okay, so in a contract of indemnity there are only two parties. One is the indemnifier and one is the indemnified person, whereas in a contract of guarantee there are three parties. One is the creditor, one is the debtor, and then also the additional surety. Okay, so in a contract of indemnity there are two parties. One is the indemnifier, that is the promiser, and the indemnified, that is the promisee, who has been made a promise that in case he incurs any loss, then the indemnifier will indemnify him. But in the case of a contract for guarantee, there are three parties, that is the principal creditor, principal debtor, and the surety. Okay, the second one, the nature of liability. In the contract of indemnity, the liability of the indemnifier is primary and unconditional. All right, so in the contract of indemnity, the liability of the indemnifier is primary and it's unconditional. That means there is no condition attached, no terms and conditions attached. Whatever liability is there of the indemnifier, it is pure. But whereas in the case of a contract for guarantee, the liability of the surety is secondary and conditional, as the primary liability is that of the principal debtor. So in the case of a contract for indemnity, if there is any loss that occurs to the indemnity holder, then directly the indemnifier has to indemnify it or reimburse it. Clear? No questions asked, and it is simple. So it is the primary and unconditional responsibility or liability of the indemnifier. But in the case of a guarantee, the liability of the surety is secondary and conditional, and secondary and conditional in the sense the main contract is between the principal debtor and the principal creditor, and only if the principal debtor defaults to pay, then in that case the liability of surety can arise. Okay, so that is the second difference on the nature of liability. In case of a contract of indemnity, it is primary, and in the case of contract of guarantee, it is secondary. All right, now let's look at the third one, the time of the liability. The liability of the indemnifier arises only on the happening of a contingency, which simply means only if the indemnity holder incurs certain loss due to the action of the indemnifier or any other person, then only the liability of the indemnifier arises. So there is a contingency, that means it may or may not happen. But whereas the liability arises on the non-performance of an existing promise or a non-payment of an existing debt. So in the case of a contract for guarantee, there is an existing debt and there is an existing promise. So when the principal debtor refuses to honor his promise or pay the debt, that is where the liability of the surety arises. Okay, time to act. Now the next difference is time to act. The indemnifier need not act at the request of the indemnity holder. Okay, so the indemnifier need not act at the request of the indemnity holder. The minute the indemnity holder incurs a damage or a loss, then the liability of the indemnifier is up and running. But whereas in the contract of guarantee, the surety acts at the request of the principal. That is only when the principal, wait one second, this is incomplete. Principal creditor. All right, so in the case of contract for guarantee, the surety acts at the request of the principal creditor, and if the request is not made, he did not act. All right, now the last difference is the purpose. The purpose of the contract of indemnity is for reimbursement of losses that may have incurred to the, that may have occurred to the indemnity holder due to the actions of the indemnifier or the other person. All right, so basically it is the reimbursement of loss, but the purpose of the contract of guarantee is for the security of the creditor. That means the creditor wants a security that in case the debtor refuses to pay him or fails to pay him, then his money should not go anywhere. All right, so this was the differences between a contract of indemnity and contract of guarantee. I request you to take about 2 to 3 minutes, go through this carefully, and then we proceed. All right, in case you have any questions, please feel free to ask me. Any questions? Please ask. Any questions? Please ask me. Okay, let's move on. Now we discuss the nature and extent of the surety's liability. Okay. Now the term coextensive with that of the principal debtor means that the surety is liable for what the principal debtor is liable. However, the liability of the surety may be less than that of the principal debtor by an express contract to that effect. All right. So first and foremost, the nature and extent of the surety's liability means the surety is liable to the maximum extent only to the amount in which the principal debtor owes to the principal creditor. His liability cannot be more than that. For example, if A gives the guarantee for B selling goods to C for rupees 50,000 rupees, that in case C does not repay the money in 3 months' time, A will pay that money. Then A's liability can only be 50,000 rupees. It cannot be more than that. But in case there is an agreement between the debtor, principal debtor and the surety, then his liability can be lesser than that also. So there can also be a agreement saying that the surety will pay only 25,000 in case the debtor defaults, and the remaining 25 will have to be taken from him only by filing a case. Okay, so the amount can reduce, but the amount can never be more than what is owed to the principal creditor. Okay. The liability of a surety arises on default of the principal debtor. So only when the principal debtor defaults or refuses to complete his promise or make his payment, that is the time when the liability of the surety arises. But as soon as the principal debtor defaults, the liability of the surety begins and runs coextensive with the liability of the principal debtor. That means in the sense that the surety will be liable for all those sums for which the principal debtor is liable. If there is a condition precedent for the surety's liability, the surety would be liable only when that condition precedent is fulfilled. A partial recognition of this principle is found in section 144, that is joining of co-surety. So the second one simply says that only when the principal debtor defaults in his promise or his duties or obligation to pay does the liability of the surety arise, and not before that. And also, once the liability arises of the surety, it runs coextensive with the liability of the principal debtor. That means both the liabilities move hand in hand. All right. And if there is any condition precedent, that means as per the contract, if there is any condition that needs to be fulfilled in order for the liability of the surety to be crystallized, then that condition has to be fulfilled, and only after that the surety is liable. All right. Let's go to the third point, where a debtor cannot be held liable on account of any defect in the document. The liability of the surety also ceases. So let's say there is a contract between A and B, where B sells goods to C. Later on, when it is and C guarantees, when there is a contract between A to B, where B sells goods to A and C guarantees the payment to B. Okay, so C is the surety. Later on, it is found out that the contract between A and B was a void contract because the consent of A was obtained through coercion or fraud. So in that case, when the contract itself is void, then the liability of the surety also ceases. Okay, so that means when the debtor cannot be held liable on account of any defect in the document, the liability of the surety also ceases. The fifth point, the surety's liability continues even if the principal debtor has not been sued or is omitted from being used. In other words, a creditor may choose to proceed against the surety first unless there is an agreement in the contrary. So tomorrow, when the principal debtor refuses to pay the money, the surety cannot say, no, first file a case against him, then when he refuses to pay or something, then I will pay. No, it is the principal creditor's choice against whom he wants to proceed first. unless there is an agreement to the contrary. If there is an agreement that first he has to proceed against the debtor and only after that the surety will pay, then the creditor has to follow that. But in case there is no agreement, then in that case, the creditor is free to proceed against anyone he wants. All right, please take about 2 minutes, go through this, and then we proceed. Any questions? Please ask me. Please take about 2 to 3 minutes. Take a minute more. Go through this carefully. This is the nature and extent of the surety's liability. Okay, now let's talk about a continuing guarantee. We spoke about the different types of guarantees. Remember, we spoke about a specific guarantee and a continuing guarantee. So let's talk about continuing guarantee in detail. Now, what do you mean by continuing guarantee? Section 129. A guarantee which extends to a series of transactions is called a continuing guarantee. Therefore, the essence of continuing guarantee is that it applies not to a specific number of transactions, but to any number of transactions that makes the surety liable for the unpaid balance at the end of the guarantee. So like we spoke earlier, specific guarantee is for one particular transaction or one particular debt, but a continuing guarantee is for a series of transactions that may occur, or it may be kind of a blanket guarantee that in this month, whatever B purchases, C is guaranteeing the payment. Okay, so that is a continuing guarantee. All right, that's not a specific guarantee. Let's take an example. A, in consideration that B will employ C in collecting rents of B's zamindari, promises B to be responsible to the amount of rupees 5,000. Okay, now for due collection and payment of C by those rents, this is the continuing guarantee. So now A has his cousin C who he wants to get a job. So A tells B that please employ C for collection of your rents to make him an estate manager, and he will collect the rent every month and give it to you. And in case he fails to do so, I will be responsible to the amount, to the extent of rupees 5,000 rupees. Okay, so this is a continuing guarantee. That means whenever C defaults, A will be liable up to rupees 5,000. Okay, so this is one example of a continuing guarantee. Then let's look at example number 2. A guarantees payment to B, a tea dealer, to the amount of rupees 100 for any tea he may from time to time supply to C. B supplies C with tea to above the value of rupees 100, and C pays B for it. Afterwards, B supplies C with tea to the value of rupees 200. C fails to pay. The guarantee given by A was a continuing guarantee and he accordingly is liable to pay B to the extent of rupees 100. So in this case, C seems to be a very tea lover. He loves tea a lot. So A guarantees to B, who's a tea dealer, that please give C how much ever tea he wants and up to rupees 100 I guarantee you. Whenever he defaults, 100 rupees, come and take it from me. So C takes tea from B and first he pays him 100 and then secondly he takes tea to the value of 200 and C fails to pay. So the guarantee given by A can be invoked, whereas he is allowed or expected to pay rupees 100 to B, the dealer. So this is a tea dealer. This is a continuing guarantee. Please take about a minute and go through this and then we proceed. Any questions? Please ask me. Take a minute or so and then we proceed. Any questions? Please ask me. Okay, let's proceed. Now let's proceed with example number 3. A guarantees payment to B of the price of 5 sacks of flour to be delivered by B to C. Okay, so A guarantees B. A issues a guarantee to B. And B is supposed to deliver 5 flour sacks to C. Okay, B delivers 5 sacks to C. C pays for them. Afterwards, B delivers 4 sacks to C, which C does not pay for. The guarantee given by A was not a continuing guarantee and accordingly he is not liable to pay for the price of the 4 sacks. Okay, now in this case, if you see, A guarantees payment to B of the price of 5 sacks of flour to be delivered by B to C. So it was a one-time transaction to be paid in a month. So in that case, B delivers 5 sacks of flour to C and C pays for them. So that guarantee contract is over then and there. In the next thing, again, B delivers 4 sacks of flour to C and C does not pay. In this case, A cannot be held to pay B because it was a specific guarantee that he gave and not a continuous guarantee. In a continuous guarantee, the liability of the surety continues till the performance or the discharge of all the transactions entered into or the guarantee is given. Okay, so in this case it is not a Please take about 2 minutes, go through this example, and then we proceed. Any questions? Please ask me. Take about a minute more. Any questions? Please ask me. Okay, Now we go to the next topic, that is liability of two persons, primarily liable, not affected by arrangement between them, that one shall be surety of the other's default. Okay, when two persons contract with a third person to undertake a certain liability and also contract with each other that one of them shall be liable only on the default of the other, the third person not being a party to such contract, the liability of each of these two persons to the third person under the first contract is not affected by the existence of the second contract, although such third person may have been aware of the existence. So see, now this is a very simple thing. Now it might sound complicated, but please pay attention. Now A and B decide to take a loan from C. Okay, now A and B want to take a joint loan from C. Now among A and B, they make an arrangement that A will be liable if B refuses to pay, or B will be liable if A refuses to pay. Okay, so only when one of the parties makes a default, then the other person will be liable to pay. Now this arrangement between A and B does in no way affect the arrangement that A and B have with C. In case A and B both take a loan from C of 10,000 rupees and they default to pay the money to C, C can file a case against both of them. Now what was their internal arrangement, C does not know, and to be honest, C does not care about that. C gave a money to both A and B, and when the due date comes, he can ask both of them or he can ask anyone for the money. Now when he asks for the money, B can either pay 10,000 to C and claim 5,000 from A, or A can pay 10,000 to C and claim 5,000 from B. But that is in no way affecting or impacting C. C will want his money. All right. Now let's take an example. A and B make a joint and several promise note to C. A makes it in fact as surety for B, and C knows this at the time when the note is made. The fact that A, to the knowledge of C, made the note as surety for B is no answer to the suit by C against A upon that note. So like I told you, it doesn't matter what the arrangement between A and B is. C wants his money and C has given his money to A and B, and whenever he demands his money, he can demand it from both the people A and B, or either of them, or any of them. Okay, now how they prepay the money to him, what they do internally among themselves is not C's problem. All right, please take about 2 minutes, go through this, and then we proceed. Any questions, please ask me. Take another minute, carefully go through this. It might sound complicated, but it's not. It's a very simple concept. Take about a minute more, go through this. Take about 30 seconds more and then we proceed. Okay, now this is an important concept as to when is the liability of the surety discharged. Okay, that means when does the surety become free, that okay, now I have no more liability. All right, a surety is said to be discharged when his liability as surety comes to an end. The various modes of discharge of surety are discussed below. First method, by revocation of the contract of guarantee, that means by cancellation of the contract of guarantee. So once a contract of guarantee is cancelled, then automatically the liability or the answerability of the guarantor or the surety also comes to an end. Okay, by conduct of the creditor, in case the creditor agrees that okay, the surety is not required, or I'm letting go of this thing, then in that case the liability of the surety is ceased or discharged. And the third method is by invalidation of the contract of guarantee. So in case the contract of guarantee is invalid due to the essential components of a contract not being there, in that case the liability of a surety comes to an end. All right, so we will discuss and look into each topic in detail. So let's start off. First is revocation of continuing guarantee by notice. The continuing guarantee may at any time be revoked by a surety so as to future transactions by notice to the creditors. A specific guarantee can be revoked only if liability of principal debtor has not accrued. So the first case is by revocation of a contract of guarantee. In case of a continuing guarantee, like for example, a person said in the next 1 month, whatever purchases A makes from B, I will guarantee it. So that is a continuous guarantee. Now in case a person wants to cancel such a guarantee, then they can give it before, they can give a notice that effective this date, I will not be giving a continuous guarantee for this transaction, but provided the liability should not have arisen. Same thing, a specific guarantee for a particular transaction can be revoked again by notice, but only if the liability to the principal debtor has not accrued. Okay, that means it was not given rise to. Then we look at okay, now in the meantime take about a minute, go through this, and then we look at the examples. Okay, now let's look at example number 1. Okay, A, in consideration of B's discounting at A's request, bills of exchange, discounting at A's request, bills of exchange for C, guarantees to B for 12 months the due payment of all such bills to the extent of 50,000 rupees. So A gives a guarantee to B that all C's bills of exchange for a period of 1 year to the extent of 50,000 rupees will be honored by A in case C fails to pay. Okay, B discounts bills for C to the extent of 20,000 rupees. Afterwards, at the end of 3 months, A revokes the guarantee. This revocation discharges A from all the liability to B for any subsequent discount, but A is liable to B for the 20,000 rupees discount. So in this particular case, A gives a guarantee to B that in case C issues any bill of exchange and defaults on it, then for 1 year's time I will pay you the money. Alright, so within 3 months B discounts a bill for C for rupees 20,000, so that liability comes on A. But after that, A gives a notice that okay, I am no longer giving a guarantee for the bills of exchange discounted or bill discounts of C. So in that case, his liability is discharged from the date he gives notice, but he is liable for rupees 20,000 rupees, which will arise in case C defaults. Okay, so this is again a revocation of a continuing guarantee. Let's look at the example number 2. A guarantees to B to the extent of rupees 1 lakh that C shall pay all the bills that B shall draw upon him. Okay. B draws upon C. C accepts the bill. A gives notice of revocation. C dishonors the bill at maturity. A is liable to the guarantee. Now this is the case of revocation of specific guarantee. Okay, now A guarantees to B, A gives a guarantee to B that whatever bills that B shall raise on C, if C defaults, A will pay it. Okay, so B raises a bill on C. A gives his notice of revocation and C dishonors the bill or fails to pay the bill. In this case, even though it was a specific guarantee, A is liable upon this guarantee because his notice came after the bill was raised by B on C. Okay, now we look at example 3. X gives guarantee to the extent of 50,000 for the loans given from time to time by A to B. Okay, so A gives the guarantee to X gives the guarantee to A for all the loans that A gives from time to time to B. A gave a loan of rupees 10,000 to B. Afterwards, X gives notice of revocation. So A has already given a loan for 10,000 to B. After that, X has given a notice for revocation. X is discharged. Okay, X is discharged from all liability to A for any loan granted after the revocation of the guarantee, but he is liable to A for rupees 10,000 on default of B. So that means the notice given by X was after the transaction happened, that is after A gave a loan of rupees 10,000 to B. So X shall be liable to that, but then after giving his notice, he shall not be liable for any more loans that A may give to B. Please take about 2 or 3 minutes. Please read the examples carefully and ask me any questions that you may have. Please ask me any questions that you may have. Any questions? Please ask me. Okay, now let's look at the revocation of continuing guarantee by surety's death. Okay, now this is the next method of discharge of surety, discharge of liability of surety. Section 131. In the absence of any contract to the contrary, the death of a surety operates as a revocation of a continuous guarantee as to the future transaction taking place after the death of the surety. So, however, the surety's estate remains liable for the past transactions which have already taken place before the death of the surety. Now, this simply means, let's say A sells goods to B on 1st January 2020. Okay, and A sells goods to B for rupees 50,000 rupees, and C comes in and becomes the guarantor or the surety for that 50,000 rupees for B, and he tells A that in case B defaults, I will pay you that money. Okay, now the transaction happened on 1st Jan 2020. All right, so on 31st Jan, A raised a bill on B for rupees 50,000 and B failed to pay. On 2nd February, C passed away. So now we need to find out, or we need to talk about the guarantee of or the liability of the surety. Now in this case, even though C passed away on 2nd February, the bill was raised by A on 31st Jan for rupees 50,000. So that means his liability arose. Now in future, in case if B defaults to pay that 50,000 rupees, then the estates of C will have to be used to discharge the liability. But in case B pays that money, then the liability of C is over. But after C's death, that is after 2nd February, if there is any other bill raised by A on B, C or C's state will not be liable to pay that amount. That is what it means. Okay, got it? Right. Now the C is by novation. The surety under original contract is discharged if a fresh contract is entered into between the same parties or between the other parties, the consideration being the mutual discharge of the old contract. So let's say there is a new contract that has come into place. A sells goods to B. C guarantees the payment to A of the goods sold to B. Now going forward, if A and B enter into a new contract or they change the contract completely, that is called novation, and then C's liability is completely discharged. C is not liable as a surety anymore because the original contract was replaced by a new contract. Now let's look at the methods of novation. By conduct of the creditor, by variance in terms of a contract. Where there is any variance in the terms of a contract between the principal debtor and the creditor without the surety's consent, it would discharge the surety in respect of all the transactions taking place subsequent to the variance. Now please remember, the surety is standing as a guarantor for the principal debtor. So it becomes the principal debtor's duty to inform him if there is any changes in the contract between him and the creditor. In case the principal debtor and the principal creditor undergo any changes in the contract without the knowledge of the surety, the liability of the surety is discharged, and he shall no further be liable for any transactions of the principal debtor done with the principal creditor. His liability is done and dusted. All right, please take 2 minutes, go through this, and then we proceed. Take about 2 minutes, go through this, and then we proceed. Take about a minute more. Okay, now let's look at a few examples. Now let's look at example number 1. A becomes surety to C for B's conduct as a manager in C's bank. Afterwards, B and C contract without A's consent that B's salary shall be raised and that he shall become liable for 1/4 of the losses on overdrafts. B allows customer to withdraw and the bank loses a sum of money. A is discharged from his surety by the variance made without his consent and is not liable to make good the loss. So now firstly, A has a relative B, okay, and he goes to C and he says, please, B is a very good guy, please take him as a manager in your bank. Okay, so C takes the surety or the guarantee of A and appoints B as the manager in the bank. Later on, without the knowledge of A, B and C enter into a contract. C tells B that okay, your salary is increased and also you shall be liable for 1/4 of the losses on overdraft. Overdrafts are temporary credit facilities given to business organizations. Okay, B allows a customer to overdraw, and the bank loses a sum of money. Now, because the contract between B and C was made without the knowledge of A, who was the surety for B, A's liability is discharged from his surety by the variance without his consent. and then he is not liable to make any good the loss due to overdraft or any other reason, simply because the agreement between B and C was made without the knowledge of the surety or guarantor of C. That's the example number 1. Okay. Now, let's look at example number 2. A guarantees C against the misconduct of B. Okay, so A stands as a surety for B that B will not misconduct, and he gives a guarantee to C in the office of B and office to which B is appointed by C. All right, so A gives a guarantee for B or his conduct for B, and based on that he is appointed by C in his office, and of which the duties are defined by an act of the legislature. By a subsequent act, the nature of the office is materially altered. Afterwards, B misconducts himself. A is discharged from any change from future liability under his guarantee, though the misconduct of B is in respect of a duty not affected by a later act. Now, even though there is a change in the contract between B and C by the change in the act, that does not matter, and A is discharged by the change from future liability under his guarantee, though the misconduct of B is in respect of a duty not affected by the later act. Okay? All right. Any questions so far? Please feel free to ask me. Okay. Now we look at example 3. C agrees to appoint B as his clerk to sell goods on a yearly salary upon A's becoming surety to C for B. So C agrees to appoint B, but C's condition is that A will give guarantee for B. Okay. Duly accounting for monies received by him as such clerk. Afterwards, without A's consent or knowledge, C and B agree that B should be paid a commission on the goods sold by him and not a fixed salary. Hence, it is held that A is not liable for the subsequent misconduct of B. So earlier when A gave the guarantee for B, there was a different contract. Without A's knowledge, C and B changed the contract, and instead of a fixed salary, B started getting commission. So this meant that the original contract between B and C, for which A stood as a guarantor, has now been discharged, and A has no further liability on any misconduct of B. Please take about 2 or 3 minutes, go through this, and then we proceed. Take about 2 minutes, go through this carefully, and then we proceed. Any questions? Please ask me. Okay, now let's look at example number 4. A gives to C a continuing guarantee to the extent of rupees 3 lakhs for any oil supplied by C to B on credit. Afterwards, B becomes embarrassed, and without the knowledge of A, B and C contract that C shall continue to supply to B with oil for ready money, and that the payment shall be applied to the then existing debts between B and C. A is not liable on this guarantee for any goods supplied after this new agreement. So earlier A was standing as a guarantor for B for goods sold by C to B, but without A's knowledge, B and C entered into a new agreement to buy goods, to buy oil on cash basis. So then hence A's liability is discharged, and A is no longer liable to C as a guarantor for B. Okay, now let's look at example 5. C contracts to lend rupees 5 lakhs to lend to B rupees 5 lakhs on 1st March. A guarantees the repayment. C pays the rupees 5 lakhs to B on 1st Jan. Okay, A is discharged from his liability as the contract has been varied, inasmuch C might sue B for the money before 1st March. So the contract was originally to lend money on the 1st March, and for that A became a guarantor for B, but C pays the rupees 5 lakhs to B on 1st January. So because the terms of the contract have been changed, A is discharged from his liability and the contract has been varied in as much as C might sue B for the money before 1st March. So C can sue B for the money, but A is discharged from his liability. Okay, now the next method by which the liability of a guarantor is discharged is by release or discharge of the principal debtor. The surety is discharged if the creditor enters into a fresh contract, new contract with the principal debtor by which the principal debtor is released. It does any act or omission, the legal consequence of which is the discharge of the principal debtor. So in case the principal creditor enters into a new contract with the principal debtor by which the principal debtor is released, or there is any relief provided to him, then the liability of the surety or the guarantor is also released. Or if the principal creditor does any act or omission, the legal consequence of which is the discharge of the principal debtor, then in that case also the surety's liability is discharged. Please take about 2 minutes, go through this, and then we proceed. Any questions? Please ask me. Any questions? Please ask me. Please take some time, go through this, and I want you to understand all the concepts and ask me any questions that you may have. Any questions? Please ask me. All right, let's continue. Now, the next is the method is discharge of surety when the creditor compounds with or gives time to or agrees not to sue the principal debtor. Now, like you can read from the definition, if the principal creditor agrees to give time to the principal debtor or not agrees not to sue him, then in that case the liability of the surety is discharged. A contract between the creditor and the principal debtor by which the creditor makes a composition with or promises to give time or promises not to sue the principal debtor discharges the surety unless the surety assents to such contract. Okay, so again, if you see, there is a variation in the terms of the contract, or there is a new contract without the knowledge of the surety. So in case the surety knows about the contract, then his liability is there, but in case he does not assent to the contract or does not give his confirmation to the contract, then his liability is discharged. So let's look at the first one, composition. If the creditor makes a composition with the principal debtor without consulting the surety, the latter is discharged. Composition inevitably involves variation of the original contract and therefore the surety is discharged. So if the principal creditor involves in any composition with the debtor without the knowledge or without the consent of the surety, in that case the liability of the surety is discharged as a new contract has come into place. Okay, the promise to give time, where the time for the payment of a guaranteed debt comes, the surety has the right to require the principal debtor to pay off the debt. Accordingly, if it is one of the duties of the creditor towards the surety not to allow the principal debtor more time, So in case on the due date, if the principal creditor agrees to give the debtor more time, then in that case the liability of the surety is discharged, and then it is a contract between the principal creditor and the principal debtor unless and until the surety consents to such a extension. Okay, now then we see the promise not to sue. If the creditor under an agreement with the principal debtor promises not to sue him, the surety is discharged. The main reason is that the surety is entitled at any time to require the creditor to call upon the principal debtor to pay off the debt when it is due, and this right is positively violated when the creditor promises not to sue the principal debtor. So this simply means normally the surety has a right that as on the due date, first the creditor should ask the principal debtor for the money, this thing, and in case he doesn't do that, then the debtor does not pay the money, then the surety will pay the money. But in case the creditor enters into a contract and promises not to sue the debtor, then in that case the whole liability of the principal debtor is discharged. So in that case the liability of the surety is also discharged. Please take about 2 minutes, go through this, and then we proceed. Please, minute. Okay, take a couple of minutes, go through this carefully, and then we proceed. Okay, cases where surety is not discharged. First one, surety is not discharged when the agreement made with a third person to give time to principal debtor. Where a contract to give time to the principal debtor is made by the creditor with a third person and not with the principal debtor, the surety is not discharged. Please remember, one of the main conditions for a discharge of surety was if in case the principal debtor and a creditor enter into a contract or change the terms of their contract without the knowledge of the surety, then the surety is discharged from the liability. But in case the principal creditor makes an agreement with a third person for giving extension of time to the principal debtor, then the surety is not discharged because the original contract between the principal debtor and creditor are intact and there is no new contract that has come into the picture. Example: C, the holder of an overdue bill of exchange drawn by A as surety for B and accepted by B, contracts with M to give more time to B. A is not discharged. So C has entered into a contract with M and not with A or B. In this case, A is being the surety of B is not discharged simply because the agreement has been entered between C and M for extension of time to B. Alright. Now, the next one we look at is creditor's forbearance to sue does not discharge surety. It means if the creditor refuses to sue, that does not mean the liability of the surety is discharged. Mere forbearance on the part of the creditor to sue the principal debtor or to enforce any other remedy against him does not, in the absence of any provision in the guarantee or to the contrary, discharge the surety. Let's take an example. Example: B owes to C a debt guaranteed by A. Okay, so B owes some money to C and A is the guarantor for that. The debt becomes payable. C does not sue B for a year and after the debt becomes payable. So A is not discharged from his surety. So in this case, we simply see that C has not openly come into a contract with B and said that I will not sue you. But C hasn't filed a case on him for a year. Maybe he was busy or maybe he didn't feel like. So in this case, A is not discharged from his surety unless B and C enter into a contract where C agrees that C will not file a case against B. But in case C is just delaying it or does not file a case for 1 year, that does not mean A is discharged from his surety. Please take about 2 minutes, go through this, and then we proceed. Take about 2 minutes, go through this, and then we proceed. Okay. Now, discharge of surety by creditor's act or omission impairing surety's eventual remedy. Okay, if the creditor does any act which is inconsistent with the rights of the surety or omits to do any act which his duty to the surety requires him to do, an eventual remedy of the surety himself against the principal debtor is thereby impaired, the surety is discharged if it is the plain duty of the creditor not to do anything inconsistent with the rights of the surety. A surety is entitled, after paying off the creditor, to his indemnity from the principal debtor. If the creditor acts or omission deprives the surety of the benefit of this remedy, the surety is discharged. So see, the whole idea of thing is, if an A guarantees B's loan taken from C, and if B defaults, then A pays that loan to C. Okay, but then later on A has a implied contract with B where he can recover the money from B. Now if C, being the principal creditor, does anything which impairs or stops or damages the right of the surety to get the money back from the principal debtor, in that case the liability of the surety is discharged. Okay, let's take an example. B contracts to build a ship for C for a given sum, to be paid in installments as the work reaches certain stages. A becomes surety to C for B's due performance of the contract. Alright, so now B contracts to build a ship for C. Alright, now A becomes a surety to C and says that B will build the ship. In case B does not build the ship, I will repay your money. C, without the knowledge of A, prepays to B the last 2 installments. Okay, I repeat, C, without the knowledge of B, without the knowledge of A, prepays to B the last 2 installments. A is discharged by this prepayment. Now, why is this so? Let's read it again. B contracts to build a ship for C for a given sum, to be paid in installments as the work reaches certain stages. So C has to pay in installments to B. A becomes a surety to C for B's due performance of the contract. So A says, okay, A tells C that I guarantee you whatever amount you are paying there, and B will construct the ship. In case he doesn't, whatever amount you've paid, I will repay it to you. Okay. C, without the knowledge of A, prepays to B the last 2 installments. Now obviously C did not have to pay the last 2 installments, prepay the last 2 installments before the due date. But the fact that she prepaid it before the due date discharges A from his prepayment, or discharges A from his liability as a surety, because she has gone against the contract. Because in case B had not done it, then that money would have been paid by him. Alright, now let's look at example 2. A puts M as apprentice to B and gives a guarantee to B for M's fidelity. B promises on his part that he will at least once a month see that M make up the cash. B omits to see this is done as promised and M embezzles. A is not liable to B on his guarantee simply because there is a breach in the contract, as even B has not performed his duty. Alright, so please take about 2 minutes, go through this, and then we proceed. Please take about 2 minutes, go through this, and then we proceed. Please take a minute more. Okay. By invalidation of the contract of guarantee. Now, this is another method or way in which the liability of the surety is discharged. Guarantee obtained by misrepresentation is invalid. Any guarantee which has been obtained by means of a misrepresentation made by the creditor or with his knowledge and assent concerning the material part of the transaction is invalid. Like we saw, the essential elements of a contract are free consent, and in case any guarantee has been obtained by a creditor by means of misrepresentation or by lying or by fraud, then that entire contract of guarantee is invalid. And once a contract of guarantee is invalid, then this discharges the surety from his liability. All right. Now let's look at guarantee obtained by concealment is invalid. Any guarantee which the creditor has obtained by means of keeping silence as to the material circumstances is invalid, as then we can also say that at times silence may amount to fraud, and any contract entered into by fraudulent means, there is an invalid or a void contract, and if the contract is void, then that discharges the liability of the surety. Okay, let's look at examples. Example 1. A engages B as a clerk to collect money from him. B fails to account for some of his receipts, and A in consequence calls upon him to furnish security for his duly accounting. C gives his guarantee for B's duly accounting. A does not acquaint C with the previous conduct. B afterwards makes a default, the guarantee is invalid. Now see, A appoints B as a clerk to collect money. B goes on collecting money, but in the beginning B makes some theft or shortage in the money. So for this, A tells him that please go and bring a guarantor or a surety. So B brings C. Now C, when C guarantees for the conduct of B, A does not tell C about B's previous misconduct, that he was caught stealing money. So B afterwards makes default again. Hence the guarantee is invalid because the guarantee was obtained from C by concealment of material facts. Okay. Then we go to example 2. A guarantees to C the payment for iron to be supplied by him to B. Okay, so C is supplying iron to B, and A guarantees that for an amount of rupees 2 lakhs. 2 lakhs. B and C have privately agreed that B should pay 5 rupees per ton beyond the market price, such excess to be applied in liquidation of an old debt. This agreement is concealed from A, and A is not liable as a surety for two things. One is the concealment of material facts, and also there is an agreement that has happened between B and C without the knowledge of A, who is a surety. All right, please take about 2 minutes, go through this, and then we proceed. Please take about 2 minutes, go through this, and then we proceed. Let's proceed. Now, rights of a surety. Okay. Now, the surety enjoys the following rights against the creditor. Firstly, its rights against the creditor, then rights. Please remember, there are various rights that a surety has. First is rights against the creditor, rights against the principal debtor, and if there are more than one sureties, then rights against the co-sureties. So first, let's read the rights against the principal debtor. The rights of subrogation, section 140. Now, where a guaranteed debt has become due or default of the principal debtor to perform a guaranteed duty has taken place, the surety upon payment or performance of all that he is liable for is invested with all the rights which the creditor has against the principal debtor. It simply means, let's say A sold goods to B for rupees 50,000 and C guaranteed this transaction of sale of goods from A to B, and he became a guarantor for B. Alright, so B defaulted. B did not pay the 50,000 to A. So on that day, A called upon C to pay that 50,000 to A. And C paid that 50,000 to A. Immediately upon the discharge of the liability of the surety steps into the shoes of the principal creditor and then can claim that 50,000 rupees back from the principal debtor. That event is known as subrogation. That means substitution. Alright. Now, implied promise to indemnify surety. In every contract of guarantee, there is an implied promise by the principal debtor to indemnify the surety. The surety is entitled to recover from the principal debtor whatever sum he has rightfully paid under the guarantee, but not sums which he paid wrongfully. Alright, so again, this is a continuation of the first right, that whenever the surety has paid any amount which the principal debtor was supposed to pay, then the surety is entitled to get that amount reimbursed or indemnified from the principal debtor. But please here, the point to catch here is only the amount rightfully that the surety was supposed to pay. In case the surety pays any amount by mistake, that amount the principal debtor is not obliged to pay him back. Alright, please take about a minute, go through this, and then we proceed. Okay, let's take an example. B is indebted to C. That means B has to pay money to C. And A is the surety for the debt. C demands payment from A and on his refusal sues him for the amount. A defends the suit having reasonable grounds for doing so, but is compelled to pay the amount of the debt with costs. He can recover from B the amount paid by him for costs as well as the principal debt. Okay, so because A was the surety for the debt, C calls A to pay the money, A pays him the money, and also if there is any other expenses that A has incurred, then he is also authorized to recover that money from the principal debtor. Alright, that is the first example. Second example, C lends B a sum of money and A, at the request of B, accepts a bill of exchange drawn by B upon A to secure the amount. So basically, A stands as a surety for B. C, the holder of the bill, demands payment from A, and on A's refusal to pay sues him upon the bill. A, not having reasonable grounds for doing so, defends the suit and has to pay the amount of the bill and costs. He can recover from B the amount of the bill but not the sum paid for the cost, as there was no real ground for defending the action. So it simply means, in a case where A has every he is justified in protecting himself, in that case he can claim the costs from the principal debtor. But in a case where sure shot he has to pay the amount to the principal creditor and he unnecessarily files a case and incurs costs, then those additional costs he will not be liable to pay to the principal creditor, but he will be liable to recover the the surety will be liable to recover or will be entitled to recover the principal debt. Okay. Look at example 3. A guarantees to C to the extent of 2 lakh rupees payment for rice to be supplied by C to B. Okay, C supplies to B rice to a less amount than 2 lakh rupees but obtains from A payment of the sum of rupees 2 lakhs in respect of the rice supplied. A cannot recover from B more than the price of the rice actually supplied. So basically in this case, A stood for a guarantee for the sale of rice from C to B for to the extent of 2 lakhs, but C sold rice only worth of 1,50,000 to B. B defaulted, C asked A for the money and A paid the entire 2 lakhs. Now obviously he's paid 50,000 rupees in excess by mistake. So A cannot recover from B whatever amount he's paid by mistake. He can only recover the 1,50,000 rupees from B. Please take about a minute, go through this and then we proceed. Please take about a minute more, go through this and then we proceed. Okay, let's proceed. Now we see the rights of a surety against the creditor. The surety's right to benefit of the creditor's securities. A surety is entitled to the benefit of every security which the creditor has against the principal debtor. At the time when the contract of suretyship is entered into, whether the surety knows the existence of such security or not, and if the creditor loses or without the consent of the surety parts with such security, the surety is discharged to the extent of the value of such security. So let's say to secure the debt along with the guarantee, the principal creditor also has some other security. So the surety, it is the right of the surety to know about the additional security that the creditor has, and if the creditor without the knowledge of the surety discharges or disposes of that security, then that also discharges the liability of the surety to the extent of the value of the security. Okay, let's understand this with the help of a example. C advances to B, his tenant, rupees 2 lakhs rupees on the guarantee of A. Okay, so C gives B some money and A guarantees this payment to C. C has also a further security of 2 lakh rupees by mortgage of B's furniture. Okay, so C already has also has an additional security for 2 lakh rupees by mortgage of B's furniture. That means B's furniture worth 2 lakhs is already in C's custody for 2 lakhs. In addition to that, he also has A's guarantee. C cancels the mortgage. B becomes insolvent and C sues A on his guarantee. A is discharged from the liability on the amount of the value of the furniture. So this additional security that C had, this should have been disclosed and to the surety and should have been kept as long as the surety wanted. But without the knowledge of the surety, this additional security by C was cancelled. Hence, A is discharged of his liability. Let's take a second example. C, a creditor whose advance to B is secured by a decree, receives also a guarantee for that advance from A. So there is two things. C is a person who has to receive money from B. This money is secured by a decree and also he's got a guarantee from A. C afterwards takes B's good in execution under the decree and then without the knowledge of A withdraws the execution. Hence A is discharged because the additional security has been discharged. Please take about 2 minutes, go through this and then we proceed. Okay. Now next is the right to set off. If the creditor sues the surety for the payment of principal debtor's liability, the surety may have the benefit to set off, if any, that the principal debtor had against the creditor. Okay, so it means simply that if the creditor sues the surety for payment of principal debtor's liability, the surety may have the benefit of the set off, if any, that the principal debtor had against the creditors. That means in case they have any mutual amounts, if they owed each other any mutual amounts. Okay, the right to share reduction. The surety has the right to claim proportionate reduction in his liability if the principal debtor becomes insolvent. In case the principal debtor becomes insolvent, then the surety can claim a proportionate reduction in his liability. Then what are the rights of the surety against co-sureties? When the same debt or duty is guaranteed. Hi Udit Agarwal, how are you? Thanks for joining in. Welcome to my session. I hope you're doing well. Udit, if you're not on the Unacademy Learning app yet, I request you to download and start using the Unacademy Learning app. It will give you a range of special classes and plus courses to choose from. And also do not forget to follow my profile there. All right, Udit, if you can hear me. Okay. Now the rights against co-sureties. Co-surety is liable to contribute. Hi Himanshi, in another 5 minutes. This will finish in another 5 minutes. I'm glad you're part of the session. Thank you so much. Okay, another 5 minutes. Co-surety is liability to contribute equally. Equality of burden is on the basis of co-suretyship. There is contained in section 146. When two or more persons are co-sureties for the same debt or duty, either jointly or severally, and whether under the same or different contracts, and whether with or without the knowledge of each other, the co-sureties, in the absence of any contract to the contrary, are liable as between themselves to pay each an equal share of the whole debt, or that of the part which remains unpaid by the principal debtor. So it simply means when there is more than one surety. Okay, thanks Udit. Thanks Himanshi. When there is more than one surety, then it is understood that both of them are equally liable to pay the debt which the principal debtor has failed, or the balance of the amount. Okay, let's look at some examples to understand. Example number 1. A, B and C are sureties to D for a sum of rupees 3 lakhs lent to E. E makes a default in the payment. A, B and C are liable as between themselves to pay rupees 1 lakh each. So A, B and C are co-sureties to a debt of rupees 3 lakhs which was guaranteed to D on behalf of E. So E defaulted. So the 3 lakhs has to be divided by 1 lakhs has to be paid by each of the co-sureties. Let's look at the, where is the cursor? Okay, let's look at the second example. A, B and C are sureties to D for the sum of rupees 1 lakh lent to E. And there is a contract between A, B and C that A is to be responsible to the extent of 1 quarter, B to the extent of 1 quarter, and C to the extent of 1/2. E makes a default. As between the sureties, A is liable to pay 25,000, B is liable to pay 25, and C 50, because between the co-sureties there was a agreement that A pays 25%, B pays 25%, and C pays 50%. So E defaulted and A paid 25%, B paid 25%, and C paid 50%. The liability of co-sureties bound in different sums. The principle of equal contribution is, however, subject to maximum limit fixed by a surety to his liability. Co-sureties who are bound in different sums are liable to pay equally as far as the limits of their obligations permit. I request you to take a minute, go through this example, and then we proceed. Okay, or I think it's not important. So these two examples again are not very important, so don't break your head too much on this. So now with this, we conclude today's session on the contract of indemnity and guarantee, and I hope you found the sessions useful. Before I can leave, I would like to remind you and reiterate a few points that Crack CA exams with us is a vertical of Unacademy, which helps you in the preparation of the CA Foundation, Intermediate and Final examinations. And the Crack CA exams with us Foundation of Unacademy provides you top educators, quality content, and a great learning experience. So yes, come, let's crack CA exams with Unacademy, which is India's largest online learning platform. Okay, and like I told you, there are 3 platforms on which Unacademy works. First is YouTube, what you're watching today. Then there are special classes. And then most importantly, there is a plus platform. The YouTube and special classes are absolutely free sessions or free classes. And YouTube is what you're watching now, and special classes are provided on the Unacademy learning app. Okay, and these sessions are very important. Even the special classes contain a lot of useful and valuable information which will help you in your preparation for the CA Foundation and intermediate examinations. So I request you to go on to the Unacademy learning app and view all the special classes that could be of interest to you. Even I have taken many special classes there. But now let's talk about the Plus platform. The Plus platform of Unacademy is a payment-based subscription model, and which provides you subscription packages for the various durations in the CA Foundation and Intermediate course. I will tell you about the packages in the following slides. Why I recommend you and encourage you to become part of the Plus platform of Unacademy is due to the following 4 reasons. Firstly, you get daily live classes where you get to chat with your educator, engage in discussions, ask your doubts, and ask and answer polls, all while the class is going on. You do not need to wait for any particular time, end of the session or a weekend. You can now do this right on real-time basis when the class is going on. The second important reason why the Plus platform of Unacademy is recommended to you is because the Plus platform conducts live tests and quizzes at regular intervals to help you evaluate your preparation and also get an analysis of your performance. The various mock tests and quizzes that are conducted on the Plus platform of Unacademy help you to identify your weak areas, your strong areas, and your not so strong areas, so that adequate time can be spent to these areas according to the importance. Like, for example, you can spend more time on weak areas, a little lesser time on not so strong areas, and less time on strong areas. The third reason why the Plus platform of Unacademy is recommended and encouraged to you is the courses provided in the Plus platform are structured courses. They are structured in the sense that they are prepared in line with your exam syllabus to help you best prepare for it. So once you finished a particular course on the Plus platform, you can rest assured that you finished the syllabus for your examination without missing out any important or major point. And lastly and most importantly, the one subscription to the Plus platform of Unacademy provides you unlimited access to the live and recorded courses of your favorite educators and favorite topics to watch from the comfort of any of your devices. You can watch it from your mobile phone, tablet, laptop, or desktop, and you can watch it from anywhere. You do not need to be in your house or any place. You can watch it from anywhere at any time. There is no restriction. All you need is a good internet connection and a data plan, which most of us are blessed with today. So I again encourage you and request you to get onto the Plus platform of Unacademy to enhance and accelerate your preparation for the CA Foundation and the intermediate courses. Like I told you, the special classes and the Plus platform are available on the Unacademy learning app. Now, how do you get the Unacademy learning app? Please go to your Play Store and type Unacademy learning app, download the Unacademy learning app and register on it using the OTP that you get on your mobile phone. It is as simple as that. So all you need to do is put your mobile number, you get an OTP, and you've registered on the Unacademy learning app. Now what happens once you register on the Unacademy learning app? It opens your world to the world of courses, resources, content, live and recorded sessions that Unacademy has to provide to you in order to accelerate and enhance your preparation for the CA Foundation and intermediate examinations. While the special classes are absolutely free of cost, the Plus platform is a payment-based subscription model, which I told you in the earlier slide, and in the next slide I will tell you about the various packages that are available. So I request all of you to get onto the Unacademy learning app if you have not done so yet, and for those of you who have done it, I thank you for your support and request your support in the future as well. Okay, now here is the, like I told you, Plus is the payment-based subscription model, and the various packages for the CA Foundation and Intermediate subscription in the Plus platform of Unacademy are as follows. The packages are for 1 month, 3 months, 6 months, 12 months, and 24 months. The 1 month package normally costs you rupees 3,500. The 3 month package costs you rupees 8,750. The 6 month package costs you rupees 14,000. The 12 month package costs you rupees 17,500, and the 24 month package costs you rupees 21,000. Before you make a choice of your package, please do not forget to use the code Prathik to get a discount of 10% on the above listed price. I repeat, Prathik, P-R-A-T-H-I-K, to get a discount of 10% on the above listed price. So the after discount price of the various packages are: the 1 month package will cost you rupees 3,150. Okay, the 3 months package will cost you rupees 7875. The 6-month package will cost you rupees 12,600. The 12-month package will cost you rupees 15,750, and the 24 months package will cost you rupees 18,900. So you see immediately the saving of 10% that you get immediately. Now, I would personally recommend you to go for the 12 months or the 24 months package, and this is for the following reasons. Firstly, it is cost effective. So if you see the difference between the per month cost of the 1 month package and the per month cost of the 12 months package, there is a major saving that you've already made. And secondly, as the CA Foundation and Intermediate course is provided to you in one package, it makes sense for you to go for the 12 months package because it normally takes about a year's time for you to prepare and clear the CA Foundation and the intermediate course. So in case you're getting a 1 year duration package at a very cost effective price, it makes sense for you to go for the 12 months package at least. Okay, but while doing so, please do not forget to use the code Prathik to get a discount of 10% on the listed price. All right, now like I told you, there are various special classes on the Unacademy learning app, and here are a snapshot of few of the special classes out of the many that I have taken. I have taken special class on revision test papers, May 2019, business laws issued by the Institute of Chartered Accountants of India, the Sale of Goods Act, the Indian Contracts Act, Companies Act. Now, if you see part 1, part 2, part 1, because there are a lot of parts and all these topics have been comprehensively dealt with in the special classes that are there on the Unacademy learning app. So in case you have not seen them yet, I request you to get onto the Unacademy learning app and go through the special classes that I have taken and gain more insight, as these special classes also are very important and help you in your preparation for the examinations. And on top of it, these are absolutely free, so you do not need to pay anything for these special classes. Okay, so and here for your convenience, I have given links of a few of the special classes that I have taken on the Unacademy learning app. So you can either click on these links or copy and paste these links in your browser to directly take you to the Unacademy learning app and take you to the session so that you can attend it and benefit from it. I have taken special classes on Indian Contracts Act, the special class on Sale of Goods Act, special class on the Indian Partnership Act, special class on the Limited Liability Partnership Act, special class on the Companies Act, special class on basics of communication, special class on accounting concepts, and also special class on the various revision test papers issued by the Institute of Chartered Accountants of India. So please do attend any of the sessions that you like, and these are out of the many sessions that I've taken over there on the Unacademy learning app. So I request you to get onto the Unacademy learning app as soon as possible and go through these sessions in order to derive benefits for your examination. And mind you, these are absolutely free of cost. So before I proceed, I welcome you all to Let's Crack CA Exams with Unacademy, India's largest online learning platform. And also do not forget to use the code Prathik to get a discount of 10% on the listed price of your Plus subscription. So I really hope you found the session useful today. In case you did, please do give me a feedback. And I look forward to seeing you all on the special class platform on the Unacademy learning app and the Plus platform of Unacademy. Until then, take care and goodbye. And my next session on YouTube is tomorrow at 5 p.m. and again at 9 p.m. And I will be taking a lot of special classes on Thursday, Friday, Saturday, and Sunday on the Unacademy learning app. So I request and look forward to seeing each one of you there. Okay, and these will be on topics that will help you in your examination. Thank you so much. Good night and take care.